Hey, Risa, this Ron, I'm just here for a David Thomason arraignment. That's all I have. Okay.
Okay, that's my case.
Okay. And I've sent some letters and some statements and some other stuff. I know you probably didn't have a chance to look at it, but that's been a while. But
It should be, and I think it's been a while since you sent it. 'Cause I
yeah.
believe you sent it to me, and it should be in the case file.
Okay. All right. I just want to let you know that's the only one I got. So maybe we could, once you get yours going, maybe you can help me get that one called.
Okay, is he there with you?
Yeah, he's here. He's
Okay.
he's across the desk.
Okay, all right. I'll see what I can do.
Thank you.
I'm online.
Incident. Additionally, Mr. Lawrence is the only person that has indicated there was any type of self-defense claim.
Or do you have any other witnesses? Williams? Mr. Hampton, is that Mr. Thomason that's present with you?
It is, Judge.
All right.
He's here for arraignment today.
All right. This is 20 CR 396. It is a indictment that was returned back in November of 2020. Can you tell me Mr. Thomason's address?
Yes, Mr. Thompson is currently 203 Scotty Drive.
Okay.
Wait a minute, he's changed it.
Yeah, I'm at my mom's right now. It's 2680 Harry King Road.
He's at his mother's, 2680 Harry King Road, Judge.
All right, 2680 Harry King. Good deal. Is his date of birth 8/29/83?
Correct, Judge.
All right. Do you want to have a formal arraignment and formal explanation of rights?
No, Your Honor. At this time, we would waive any formal reading, waive the reading of his rights, acknowledge his identity, enter a plea of not guilty, and reserve any and all motions associated with the proceeding.
Okay.
This has been pending for a while, and I talked to Ms. Gardner. We've sent some information, but so hopefully we can have a meaningful pretrial at some point, I guess, which will be the next step.
Yeah, right now, I'm a little cautious about when we come back in May, there's going to be a lot going on, and I would be willing to maybe put this one over into the first week or two of June, if that would help you.
Yeah, that's fine. Just whenever Your Honor wants to set it.
So why don't we look at June let's call it the 14th. How about that?
Okay. Let me get to that real quick. Judge, it looks surprising. Oh, I got a divorce trial set for that day. It's surprising me that I do, but I do have one. Starts at 9 o'clock. So That might not
This
be
would
it.
be one, this would be at 1. So do you think you'd be done or?
It's set, we set it for all day. It's when Keith Wilcutt's on the other side. It's, there's no children, but there's some difficult case to deal with.
Well, do you want it to go over to the 21st then?
That would probably be safer. And that's fine for me.
All right, 21 June 2021. Mr. Hampton, the only other thing I want to point out is I believe, and this is kind of a technical matter, but Mr. Thomason had made bond in district court. When he got indicted, I just ordered that he could remain on the same bond and have a summons served on him. It doesn't appear that the summons ever actually got served, so I just wanted to reiterate to you all that, that he's on the bond conditions that he made when he got released in district court.
It's fine, Your Honor.
Okay?
Yeah, we'll waive any, if there's a way to stop him from having to chase him down and serve him, that's fine. We'll waive any receipt of the summons at this
I'd
point.
say the last summons they issued, the court date would have been today on it. So if he hadn't gotten served with it, we just won't reissue another one.
Okay, all right. We'll be here on 21st.
All right, thank you. Mr. Thompson, stay in touch with your attorney and follow your bond conditions, okay?
Yes, sir, Judge.
All right, thank you.
Thank you.
Judge, there's Wendy Diener. She's at work at the Corvette plant. It's a motion I have to set a hearing.
Okay,
And I know that she has made some payments yet recently. So what I would really like to do is just set it for a review, continue my motion generally, set it for review sometime in July to see if she's continued to make payments.
all right. That's, yeah, it looks like I can't tell when the most recent payment, but it looks like there was at least something paid in March. So, Ms. Gardner, what are you thinking? You said July, maybe?
Yes.
All right. So why don't we review it on 26th July? The motion can just be passed generally, meaning that it's not withdrawn, but we're not going to pursue it right now. If you'll get back on a schedule of making payments and doing a good job with that, okay?
Sounds good.
All right. So that'll be 10 o'clock a.m. on July 26th.
All right, very well.
And unless something really strange happens, we will be meeting in person then. So if you happen to still need to, if you make contact with somebody and they tell you don't need to come, that's one thing. But all
Okay.
other things being equal, your personal appearance will be required.
Okay,
All right.
all right. Thank you.
Thank you. All right, let's see. I have got a lot of these jail facilities. It doesn't identify who they are. Obviously, Taylor County is identified there because the background says Taylor County. At one point I had Montgomery County on here, but I don't know if I still do. There we go.
Yeah, we're still here.
Is that, oh, all right. So that's Montgomery County.
Montgomery, yes.
Good deal. Thank you. I believe the issue with that, I just got a phone call that I think that's Mr. Spears' case. I think he's the attorney in that case. And, but I might be wrong.
Judge, I think Jason Booth is there and
Yeah.
Lee Davis represents him.
Oh, okay. For some reason I had it in my mind that it was Julio Alonso that was there.
Your Honor, I'm sorry, did you want to go ahead and take up that case now or?
Yeah, let's do that. Those guys have been waiting for a minute. So let's go ahead and take up the Montgomery County defendant, which is Jason William Booth.
Yes, Your Honor, Lee Davis for Mr. Booth. Your Honor, I just need a little bit more time. I've talked to Mr. Booth. I've talked to the Commonwealth. if we could possibly pass this just 1 week to give me a little bit more time to see if I can change something in this case, if that would be okay with the court and the court schedule and the Commonwealth.
Mr. Davis and I talked this morning about this, and I'm fine with continuing a week. He doesn't have a copy of the offer. I'm going to send that to him, and then he's going to attempt to get in touch with Mr. Booth before next week.
Right here.
Yeah. I don't have a problem with it as long as the guys up there in Mount Sterling can accommodate us. I don't know if they can next week.
Yes, we can.
All right, if we did the same time roughly.
Yes, that'd be fine.
I think you guys jumped on here at 10 o'clock your time instead of 10 o'clock our time. That might be why you've been on for a minute, because
Yeah.
we're on that slow time. So
Yeah.
if we do the same time next week, you can jump on, but it'll be 11 on your clock.
Okay.
All right, Mr. Davis, we can do that then, okay?
Yes, thank you, sir. I appreciate it.
Do we need to make any special arrangements while we've got Mr. Both on here, just for you all to talk about communicating
No.
with him, or has that not been a problem?
No, that's not an issue. Montgomery County's been very nice.
Good, thank you.
Thank you, Your Honor. May I be excused?
Yeah, we'll go over to next Monday then, all right?
Thank you, sir.
4:26, 10 a.m. Central Time.
This was turning Ain't that, he back again?
All right. And let's see, I got Taylor County. Taylor County has Mr. Blair.
Yes, Your Honor.
I believe Ms. Myers, is this your case?
It is, Your Honor, and I'm not sure if the paperwork has caught up with the file yet. I had just received the signed plea paper. Okay, good deal.
I've got it. Well, I haven't read it yet, but assuming that it is signed, then I've got it. That looks to have a signature on it, and that looks to have a signature on it. Yeah, I think we're ready to go. Mr. Blair, I am going to, it's what we call, I'm going to add a pin to your video so that you're pulled up here where I can see you. All right. So you are Brandon Keith Blair.
Yes, sir.
All right. Mr. Blair, would you raise your right hand for me, please? Do you swear or affirm that your testimony to me will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Thank you. I'm going to go over some things with you here, and I want to make sure that you can see them because this is how I prefer to do it, and it's a lot easier when you're standing right here with me. But if you can't see this, we'll come up with a different plan. But this is a document that is called the motion to enter a guilty plea. Does that look familiar to you?
Yes, sir.
All right, and you see it's got your name on it right there. It's got your case number on it right over here. On the second page, it has a signature line. It looks like a signature that could be yours. I've never seen your signature before. Do you think that's your signature?
Yes, sir.
All right. The other document that I have is titled Motion to Enter a Plea of Guilty. Again, that's got your case number and your name. It's got your charges on it. It's got some amendments of the charges. And then down at the bottom of the next page, or well, on the next page, it's got a signature line, and right where your name is, there's another signature. Is that your signature as well?
Yes, sir.
All right. Did anybody force you to sign either one of these documents?
No, sir.
Do you feel like you had all the time you need to consider whether you were going to sign them, to read over them, to discuss them with your attorney, and to discuss in general the case with your attorney?
Yes, sir.
All right. And once you did all of that, you did sign both of these documents, correct?
Yes, sir.
Do you feel comfortable that you understand what you signed?
Yes, sir.
All right. You feel comfortable that you are of sound mind today?
Yes, sir.
In other words, do you feel like your judgment is impaired for any reason, or that you are under the influence of any kind of substance, whether it is a legal substance or not, that is impairing your judgment?
No, sir.
All right. Do you understand that you have the right not to incriminate yourself. And if you plead guilty and I accept your plea of guilty, you will be waiving that right.
Yes, sir.
You understand that you have the right to a jury trial where the Commonwealth would have the burden of proving guilt beyond a reasonable doubt. You could confront and cross-examine the people that testified against you. You could put evidence on in your own defense, and you could appeal the outcome. If you plead guilty, you waive each of those rights.
Yes, sir.
All right. Mr. Blair, in this case, I'm looking at the Commonwealth's offer on a plea of guilty, which is the second of those two documents that you and I just looked at. Your charge at the time of the indictment were as follows: count one, rape in the third degree, that is a Class D felony. Count two, persistent felony offender in the first degree, that is an enhancement of your sentence. The Commonwealth agrees to amend count one to unlawful transaction with a minor in the second degree, which is in and of itself also a Class D felony, but it is, there are some differences in that felony from the prior one. And persistent felony offender in the second degree, the Commonwealth agrees to amend to, in first degree, the Commonwealth agrees to amend to persistent felony offender in the second degree.
Yes, sir.
The recommendations of the Commonwealth upon your guilty plea to those amended charges would be a sentence of 5 years on count one, a time enhancement on count two, resulting in a total sentence recommendation of 7 years, plus the possible fine and court costs. Conditions of the Commonwealth agreeing to this plea include that you would not have contact or communication with the victim or family thereof. The Commonwealth is opposing probation. The Commonwealth agrees that 3 years would run concurrently with your case in Taylor County, which was 17 CR 217. And 4 years would run concurrently, and 3 years would run consecutively. Is that your understanding of the offer from the Commonwealth?
Yes, sir.
All right. Other than what I just talked to you about, did anybody promise you anything to get you to plead guilty?
No, sir.
Has anybody threatened you to try to make you plead guilty against your will?
No, sir.
Do you feel like I am making you plead guilty against your will today?
No, sir.
All right. Mr. Blair, are you acknowledging here today that on or about May 13th, 2020 in Barron County, Kentucky, you committed the offense of unlawful transaction with a minor when you knowingly caused a minor to engage in criminal activity constituting a felony?
Yes, sir.
Are you also acknowledging that as you stand here, you are a persistent felony offender in the second degree because you are over 21 years of age? You were more than 18 years of age when the underlying offense was committed. And you have previously been convicted of a felony in Taylor Circuit Court, case number 17 CR 00217.
Yes, sir.
All right, Mr. Blair, I'm going to accept your plea of guilty to the amended charges in the Commonwealth's offer. Are you asking for a separate sentencing date with a pre-sentence investigation report? Or do you wish, because you are in custody, you can waive that separate proceeding? And are you asking to do that and be sentenced today? That is up to you.
Yeah, I'd go ahead and be sentenced today.
All right. So, Mr. Blair, having accepted the plea of your plea on the Commonwealth's offer, I'm going to sentence you in accordance with the Commonwealth's offer, giving you the benefit of the agreement that you reached. Count one will be amended to UTM second degree. And on a plea of guilty, you'll be sentenced to 5 years. Your fines and court costs will be waived because you're going to be in custody for at least the immediately foreseeable future. So it's not reasonable to expect you to pay that. Count two will be amended from first degree PFO to second degree. That will enhance your sentence from 5 to 7 years. That sentence will be served by running 4 years concurrently with your 17 CR case in Taylor County and 3 years consecutively to that sentence. Is that, do you understand?
Yes, sir.
All right. Do you have any questions?
No, sir.
All right, then I believe that's all I have with Taylor County, so we can let you folks go, okay?
Thank you, Your Honor.
Thank you. Good luck. All right. Let's see here. What else I got on my agenda? I believe I saw the Marshall County Jail. Mr. Bell, you're on here, aren't you? That's your guy, Mr. Ginter.
Yes, sir.
And there's Marshall County chiming in here.
Yes, sir. He's still getting ready. He should be down momentarily. He's taking his time, I guess, but he's on.
Oh, well. Let's, why don't we, just while I've got everybody here, we'll just stick with it. Mr. Well, Johnny is, oh, there's Mike. Okay. Mike, this is your case, isn't it?
Yes, sir, it is.
All right. Is there anything that you guys want to be in the process of chatting about while we're waiting for Mr. Ginter to get up here?
I mean, I've made an offer before. I think Mr. Bell was having issues trying to speak to Mr. Ginter about it. One update I have is I've talked to the Commonwealth Attorney in Marshall County, and they've set a trial date for him in July. We haven't set a trial date here yet, but that was part of the things that we were talking about.
And from my conversation with Mr. Ginter, at this time, Judge, the only thing that I think I have left to do is to set a trial date, and I don't believe he wants to accept the offer. Or he didn't the last time I spoke with him.
He's here, Your Honor.
Okay, thank you. Well, give me a minute here to start looking for days.
We can set, I don't know what the schedule is looking like, Judge. Since his trial's coming up in July in Marshall County, I mean, we can set it out a ways. It's an older case, but I don't know what days you're going to throw out there.
Can I ask a question?
What's your question, Steve?
Johnny, when am I going to be able to talk to you?
I can call you anytime, or you can call me anytime like we did last time. Okay, well, she just told me you couldn't call here. Well, I can call and get something set up. I can call tomorrow and talk to you.
Okay. If you can call me, Johnny, then we might can get this resolved.
Okay, well, I'll give you a call tomorrow. The other thing that you had asked me about on the federal side, that I never could get nothing to work through there.
Okay. Well, that's why I said if you'll call me, we might can get this resolved.
Okay.
Hey, Johnny.
Yeah. Go ahead, Mike.
Johnny, that the federal issue you were talking about, is that in relation to what's going on in Marshall County, or is it what we discussed here in Barron?
Well, it was just I had called on his behalf, sort of as an omnibus settlement with everything, and we weren't able to get that to click. But Judge, if there is a chance of resolving it, I know how backed up we're going to be and things. I'm that way myself. I guess we could put him off a week or two if we can get him back on here and let me talk to him. And there's no sense setting a trial date if we're not certain it's going.
Yeah, I think we've worked out the issues we were having with getting Mr. Ginter on, from Marshall County, because they had a guy that was out with COVID, and then I think his wife, the guy that was kind of helping to coordinate the Zoom meetings and stuff, he was out, and then, or vice versa, his wife was out and then he was out, and so he ended up being out of pocket for a while, and things just, we got a plan worked out, and it worked today, so I think it'll work next time too. I would go to next Monday, or we could go to, I mean, I'd prefer it next Monday because that's, we'll still be doing everything on Zoom. Once we get after that, we'll be kind of doing the hybrid. It's going to just make things a lot more complicated. So
Next Monday's fine with me, Judge.
yeah, if you think you can get him talked to, we'll just try to do next Monday at 10, assuming that doesn't, that the guys over there in Benton don't know right away that we can't do that.
No, it sounds good, Your Honor. We can get it done.
All right, super. So that's what we'll do. And then you and Mr. Ginter get a call. We don't lose that much if if you all still can't do anything and we get back here a week from now and we're trying to set a trial then, I mean, we'll have pretty much most of the same things available to us that we have right now. So we're not losing much, but I won't be setting something that's unnecessary either. Okay?
Yes, sir.
All right.
I'll talk to you tomorrow, Stephen.
Yeah, we'll see you in a week then.
Thank you.
I've
All
got,
right.
Yes, sir.
Thank you.
Yes, sir.
I've got two more. If you decide you want to do them, Judge, just let me know.
All right. Who do you think? Oh, Grayson. That's Grayson. I've got Mr. Bell, let me take up. I've got Grayson County Detention on here. They've got one individual.
Yes, sir. I'll just let you know unless you got a hole somewhere.
Are all of your people in the office with you, or are they in Barron County Detention Center?
No, I've got one here and one I think is going to sign on.
All right. All right.
Tommy White signing on, Judge.
All right. I'm with you. We'll get back to you today. So looks like in Grayson County, I have got Miss Tesh.
Yes, sir.
All right. This is the Commonwealth's motion.
That's
Folks,
correct, Judge.
I need to ask you, if you're not in this hearing, to mute your device, whatever it is. I don't know what I'm hearing, but it's,
I think it's coming from.
rather off-putting. It might be from Grayson. In this case, we're just stuck with it. All right. Ms. Gardner, you want to tell me what your
Yes, Judge. This is a motion that's been pending. I think the original motion was filed maybe early 2019, the supplement in July of 2019 regarding a new felony arrest, and it may be a conviction in Indiana. And no restitution has been paid at all since 2020.
okay. This is going to, I mean, we can set this for a hearing if that's what you are
It is,
asking.
Judge.
Yeah. We will need to be sure that we appoint counsel for Ms. Tesh. And we will set this for April 27th, I guess, 30.
That's fine, Judge.
Denise, do you know who will end up getting this one out of your office?
I will be giving this one to Xanda.
All right, so Ms. Myers is on here. Ms. Myers, just some things that it might help you to know, because there hadn't been anything filed in this case in some time. The supplement was filed in July of 2019. I think it's possible, at least, that Ms. Tesh was incarcerated in Indiana at that point, because that's what the supplement is about. Ms. Gardner pointed out that there was restitution owed that hadn't gotten paid, which is true, at least by looking at the record. I think she's been in custody one place or another, during some of that time. And she also has probation out of a Grayson County case, which was a 7-year sentence, but I do not know if it is, that may be done at this point. I think she was set to get off of it, but I don't know if they ever revoked her or what they did or just let it expire. I really don't know anything about it. But I'm just trying to give you the benefit of my very limited recollections of what's going on in this case, because nothing's happened for a couple of years.
She's not held as a federal inmate or anything in Grayson County, is she?
Not that I'm aware of.
Okay.
But yeah, but she is, as you can see, in Grayson County, but I think it's probably they're just holding her on our warrant and maybe one of their own. I don't know. Okay.
Thank you, Your Honor.
We're gonna put it on next Tuesday at 1:30. All right, that's got that one taken care of. Thank you all. What did I say? 26? 27. Thank you. True that. All right, that looks like all of the jails. We also, for anybody that's following along at home, we had Cody Holly on the docket. He is in Shelby County Detention Center. They asked if we could move him to next Monday because they had court today. You know, they I think serve a couple of different counties, and so they were tied up today, but they weren't going to be tied up next Monday. So we've moved his whatever it was that we had him on for, we've moved it to next Monday. Okay. Yeah, it'll still be a team. Oh, yeah. Yeah. Well, it'll be on the 1 o'clock docket. I apologize. They couldn't do 10. Appears to be all of the jails. So let me get Bonnie pulled up here. Johnny, which case did you have? Oh, wait, you didn't have anybody in custody, did you?
No, sir.
Who do you have in your office?
I've got Alan Maupin.
All right.
And then Tommy White's online.
Alan. Alan Maupin. I'm not sure how to get the rest of space.
Hey, Alan, how you doing, bro? Everything going
Oh,
good,
no,
man?
okay. I was gonna say she's in drug court. All right, Mr. Bell.
Mr. Maupin's on for arraignment, Your Honor. We would acknowledge receipt of the indictment, acknowledge Mr. Maupin being the individual named within that indictment, waive formal reading, enter a plea of not guilty, ask to reserve the right to file any and all motions pertaining to the case.
Can we confirm an address?
Yes, Your Honor. 4402 Cosby Court,
Louisville, Kentucky,
Louisville, Kentucky,
40218.
40218.
Four 4402 Cosby Court, Louisville, Kentucky.
Yes.
All right, thank you. All right, Mr. Bell, I'm going to put you down here then as representing Mr. Maupin, he will be entering a plea of not guilty. We'll set a pretrial conference. I would like to look at maybe June 14th.
Now, what time, when do you leave again now?
In June.
No, I'm just trying to check. He's here 30 days and gone 30.
Oh, yeah, yeah.
This Wednesday, that passed, and I got a 28 days, whatever from there.
Well, when's he leave out again?
He's got cataract surgery.
7, 14, 21. He'll leave out again May the 12th, Judge. And then 7, 14, 21. And he should be back then until he'll be back the 9th. So the June 14th should work.
Yeah, I mean, I guess I just want to make sure you all get a chance to talk, whether it's before he leaves or after he gets back.
Right. We'll be able to speak something before he leaves this next time.
All right. All right. So June 14th it is.
Judge, the only motion I've got pertaining to Mr. Maupin is I would ask that the court remove his ankle monitor. It's an extreme hardship when he's on the boat for 30 days at a time to keep all of the charging done and everything he's supposed to do as far as that goes. Of course, this was a wanton endangerment. The defendant or the alleged victim has been in my office a couple of times to give affidavits. I don't think there'd be any other issues as far as reasons for the ankle monitor to remain. He's living in a different city and has no reason to have any contact with her as far as that goes.
Is this Mr. Richardson? Is this you?
It is, Judge. I'm a little concerned, Judge. I remember Mr. Maupin from district court when he had a DUI down there, and his being on the boat and all that kept coming up. I'd ask for the monitor without looking further into the case. Well, whether victims come to Mr. Bell's office or not. I mean, it's a DUI third, so I'm concerned. Obviously, I'm not as concerned when he's on a boat, but when he's off a boat, that's my concern. I'd ask for you to keep it on for right now, just until the June date. And then once Mr. Bell and I talk about this case, maybe we'll work it out, maybe we won't, I don't know. But I'd ask for you to keep it on for the time being. It is a DUI third.
Yeah, I tell you what, let me, I don't know if, what I'm going to do. I would like to talk to Julie and just kind of, at the very least, maybe she'd be able to give me some confirmation of some of these, locations and that kind of thing. And I mean, if he's not ever coming to the area, it's possible that I can see my way clear to do it. I understand the Commonwealth's objection though. And I'm not promising you that I am going to do it, but before I would even consider doing it, I need to verify with her some of this stuff. And then I'll think about it. If nothing else, if I do leave that on just for this one more time, and as long as there aren't any problems, I think it would be extremely likely to get a favorable result next time I saw you. If if I confirm everything you're saying is true and if it continues to be true.
Yes, sir. Yes, sir.
Okay.
Thank you, Judge.
All right. Thank you.
Is Mr. Maupin free to go?
Yes.
Unless you want to talk to me. Stick around, talk to me, and come back wherever you want to do.
Ask Julie about it.
I need to get one more done. Judge, can we do Tommy White?
If he's on here, we can.
Tommy, you're on here, aren't you? Tommy? Who's that? 599, Judge.
Hello?
Yeah, whose phone number is 270-599-9734?
This is Rebecca Brown.
Oh, okay. All right.
I was given this phone number and a conference code to put in to speak to Judge Alexander from
Yeah.
Xander Myers?
Yeah, hold the phone. We'll come back to you.
Okay.
Johnny, I don't see him on here.
Yeah, all I was gonna do is ask for another pretrial on him anyway, Judge, but arts and arraignment, I'm sorry. Yeah,
Well,
she's calling him now to try to get him online.
all right. Just
Thank
hang
you.
in there and
Yes, sir.
I'll come back to you. All right. Let's look at,
Judge, can we take up Eric Martin? I think he's at LG Stylo 5.
yeah, go ahead.
We're ready. We're ready for final sentencing here on this case. I do have an argument to make once we get going.
All right. This case is set for final sentencing today. It was a case that started out as a pretrial diversion case, and that pretrial diversion ended up being voided. And so it was set for sentencing. There has been a PSI filed. Have you, Mr. Martin, have you been able to read this pre-sentence investigation?
Yes, sir.
All right. Mr. Spears, have you?
I have, Your Honor.
All right.
Your Honor.
Any reason not to proceed then with sentencing right now?
Your Honor, no, I just have an argument.
All right. Go ahead.
Your Honor, according to PSI, when the diversion was revoked, it prompted a 2-year sentence. I'd ask for this 2-year sentence to be probated for a period determined by the court. I think the main reason that the pretrial diversion was voided back in December was due to failure to make restitution payments. Mr. Martin currently has a job, and I believe has been making payments to the best of my knowledge. So it'd be in the best interest of everyone that he be probated so he can continue to make those restitution payments. But that's the case. I ask to be this 2-year sentence to be probated.
All right. Is Ms. Gardner, are you the one that's handling this?
I am, Judge. I don't necessarily have an objection to probation if there have been payments made, because I think prior to the motion to void diversion, when that was granted, I don't believe that Mr. Martin had made any payments at all. If he's made payments, I'm fine with probation for a period as long as it takes for him to completely pay off the restitution.
Yeah, I think that what you are saying, Ms. Gardner, is relevant, which is that he has some, there has been some difficulty getting with the restitution idea. He was ordered to pay $100 a month, and that would have been ordered back in July of 2015, which at that rate, this was, heck, that was 6 years ago or almost. So there sure would have been maybe not all of this paid, but a huge chunk of it paid. Instead, I think we're looking at something in the neighborhood of $300 or $400 has been paid over that period of time. 300 of that was paid in the last month. So, that's something that have a little bit of trepidation about as well. However, as Mr. Spears pointed out, the big thing here has been non-payment of restitution and not, out here racking up additional charges all over the place, which is our normal problem that we have with folks. So, I'm willing to give Mr. Martin a try on this restitution and making sure, or on probation, I'm sorry, and making sure that he, gets after it a little bit. I think he understands at this point. I believe probably he's had to go to jail a time or two over this, and that, I think in and of itself would impress upon him that we intend for this to get paid, So I think he's gotten the idea. I don't know, Mr. Hogan, are you representing, Officer Hogan, are you representing the probation and parole today? Maybe. Officer Coates, maybe? Anybody?
Seth?
Yes, it's me, Judge.
Your Honor,
Oh,
it's Officer
Officer Bennett.
Bennett.
All right, yeah. I didn't see him down there until I'd already spouted out your name. Officer Bennett,
Yes, Judge.
this is what we've got. We've got Eric Dwayne Martin. His case number is 15 CR 79. He is being sentenced today to a sentence of 2 years. He owes, I'm going to probate that sentence. He owes restitution of $7,667.95, which he had been previously ordered to attack at the rate of $100 a month. That was while it was pretrial diversion. The diversion's been voided, but I'm going to probate him on the same condition that he follow the rules of probation and parole, and specifically that he pays $100 a month on this obligation until it is paid in full. His probation will have to last until it is paid in full, but just on the off chance that something happens and he gets it paid sooner, I'll make the duration of his probation 3 years. If the payments are not made fully, then probation will be extended automatically. He will be under the same obligation that we do for other people that owe restitution, which is if he receives any financial benefit from the federal government in the form of a stimulus payment or a income tax refund, he cannot spend that without talking to his probation officer first if he still owes any of this restitution.
Judge,
Yes.
could we maybe in, I guess, 4 months set a payment review to see if he's been making payments?
Sure. That would be maybe August the 30th.
And if he's making payments, I don't have a problem with him not appearing.
Yeah. So the key there would be Officer Bennett, he obviously needs to be showing you all what he's paying and that. And if he's current on his payments, he's paid $100 a month by then. I do not have any interest in making him leave work or anything. I mean, we'll be meeting in person, so it isn't real easy to just step out into the parking lot and get on your phone like it is now. So, I don't want him to miss work or anything. If he's paying, and of course that's between now and then it'll be at least $400, right? So if that's been taken care of, then you can just report that, or whoever his officer is can report that to me, and we can keep him from having to come in, okay?
Right. I can do that, Judge. For now, Mr. Martin, you'll just need to contact me. I can give you my phone number if you have something there to list it on.
Okay, hold on just a second.
Well, this is a nice day outside.
Airport.
Okay, I'm ready.
All right. It is 270-791-4940.
4940?
Yes, and just call me today.
All right.
Just call me today about 12:30.
Okay, all right.
Thank you.
All right, Mr. Martin, just be sure you cooperate with your probation officer and he'll make sure you know what you're doing, okay?
Okay, all right, thank you.
Thank you. Good luck.
All right.
All right. Let's look at, I think on our jail docket, we've got Megan Ballard. I believe that that's been handled. Am I wrong?
Is she gone to treatment, Judge?
I thought so.
What the roll was in?
I was incorrect.
It's gone there. Yeah.
She's got a bed date for the 21st.
Okay.
So the answer is it has essentially been taken care of, except the magical date has not arrived yet. So once that date gets here, she should be ready to go. Okay, you follow me, Miss Ballard?
Yes, sir.
All right. Do you have any questions?
Am I getting out today or tomorrow?
Do what?
Because Candy Reed told my mama that I gotta be there at 6 a.m. Wednesday.
Yeah, I don't have a time they just came in here and told me that it was on the 21st. I didn't know what time it was. 9 o'clock? Yeah, you gotta be there at 9 o'clock on Wednesday.
Okay.
Okay? And it's
Okay.
it's just Scottsville, so you know that's not gonna be too tough to get down to. All right,
Okay.
thank you. Yeah. Linda Choke.
Yes, sir.
Judge, this is my case. I just sent Josh a message this morning. We filed a motion based on the fact that she left treatment. I think she was there around a month. She left on the 22nd, I believe. And so I think it's normally like 30 days since the time you leave. You can go back. I would be willing to sanction her in lieu of revocation, sanction her for the time it takes for her to get a bed date and then go back.
All right, so Josh, are you on?
Yeah, I'm on.
Did you catch that?
Yeah, I caught that. I hadn't had a chance to talk to her about it. Because I just got it a few minutes ago. So Linda, is that something you're willing to do?
I was wanting to try to do drug court if that's possible.
I guess, Judge,
Yeah, set it for a hearing. We'll
yeah.
go from there.
Yeah, I mean, we got a hearing next week or hearing date next week, so we can do that. And if you talk to her and y'all come up with something else, it'll still work. If not,
Okay.
it'll be in, she'll be in there next week.
That'll work.
I will say this, if you all want to do that after a conversation, then we can try to get that assessment done before next week, but I'm not going to order it up right now just because that's, I don't know that there's a possibility of it happening.
Right. I'll get up there and talk to her this afternoon, tomorrow, and I'll talk to John. We'll see if we can get something worked out.
All right. So that's going to be 4/27/130. All right. Thank you. Paul Harold Gas.
That's mine, Judge. I had filed motions to revoke his probation.
These are, Mr. Richardson, we need to set these for a hearing, right?
Yes, sir.
Yeah. That will be the 27th at 1:30. And Mr. Spears, are you
These are Greg's cases.
one of Greg's? All right, so we'll just need to pass this along to Mr. Berry, if you will. Okay? That's next Tuesday at 1:30. Thank you. Charles Dwight Harper.
I believe this one's mine, Judge. I think I filed a motion on this.
Yeah, this is based upon a report from probation and parole. That report was multifaceted. But essentially pointed out that there was a new arrest. There was also an allegation of absconding or failure to report at the very least. So
Now that I'm looking at it, Judge, I don't think I may not have filed a motion yet, but if I need to file one, I will.
yeah, I haven't seen a motion, but that doesn't mean there isn't one in the pipeline. So if you are going to file one, then I will set it for a hearing and you can just file it in between now and Tuesday.
Yes, sir.
Judge,
This
I'm,
will be Xanda's case.
This will be Miss Sanda's case. Okay.
Judge, I'm actually Mr. Harper's officer. I have a violation report pending approval right now. I can send over to you, Mike, once it gets approved.
Yeah, please.
Is that going to be different than the one you just filed the other day?
I have, he was actually just arrested on alleged new misdemeanors.
Oh, okay.
So that one's coming down the pipeline.
I got you. All
Thank
right.
you.
Hearing 27 April 2021, 1:30. All right, Mr. Harper, we shall see you then.
Great, thank you.
Ernest Jason Johnson. This is on for the Commonwealth's motion to revoke bond. The motion is based upon two alleged new arrests, 21M 161 and 21F 226. I do not know who's counsel of record on this one.
Judge, it's my case.
Yeah, I think it may be Greg on the
It is Greg.
defense side. Yeah. So I think the best thing to do, Mr. Gardner, is to set this on that revocation docket, you know, where Mr. Berry will be back and have a chance to get into it. Okay. 4/27 at 1:30. All right, we'll see you then. Christopher Kingery.
He's on to enter a plea, Judge. I think the plea documents should be in the file.
Yeah, I've got them. Mr. Kingery, is it your understanding that you have an agreement and are going to enter a guilty plea today?
Yes, sir, Your Honor.
All right, will you raise your right hand for me? Do you swear or affirm that you will tell me the truth, so help you God?
I do.
All right, Mr. Kingery. First off is this document. It's titled "A Motion to Enter a Guilty Plea." Can you see that?
Oh,
Can you see that?
partially, yes, sir. I saw it.
All right.
Yes, sir.
Specifically, this is a signature page. Is that your signature?
Yes, sir.
All right. There is also a written offer from the Commonwealth. Looks like this.
Yes,
And
sir.
the signature page on that. Does that have your signature on it?
Yes, sir.
All right. Did you read over these before you signed them?
Yes, sir, Your Honor.
Did you have time to talk to your attorney before you signed them?
Yes, sir, Your Honor.
Did anybody try to force you to sign these against your will?
No, sir.
All right. Are you under the influence of anything right now?
No, sir, Your Honor.
Do you feel like your judgment is impaired for any reason right now?
No, sir, Your Honor.
All right. Mr. Kingery, you understand that you have a right not to incriminate yourself. If you plead guilty voluntarily, then you are waiving the right not to incriminate yourself. Do you understand?
Yes, sir, Your Honor.
You have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You can confront and cross-examine the people that testify against you, and you have the right to put evidence on in your own defense. You understand that you waive those rights if you plead guilty.
Yes, sir, Your Honor.
You have the right to appeal, and you waive that right if you plead guilty. Do you understand that?
Yes, sir, Your Honor.
All right, thank you. Mr. Kingery, do you feel like you've had all the time you need to decide how you wish to proceed in these cases?
Yes, sir, Your Honor.
All right. The offer, as I understand it, is as follows. Count 1, possession of a controlled substance, first degree, first offense. On a plea of guilty, the Commonwealth would recommend a sentence of 3 years. Count 2, possession of drug paraphernalia. On a plea of guilty, the Commonwealth would recommend a sentence of 12 months. Count 3, no operator's license, the Commonwealth would agree to dismiss. Count 4, careless driving, the Commonwealth would agree to dismiss. Therefore, the total recommended sentence would be 3 years on count 1, 12 months on count 2, which would run concurrently for a total of 3 years. The Commonwealth agrees to probate your sentence for a period of 3 years on the condition that you cooperate and comply with probation and parole, follow the rules that they give you, and specifically that you get an assessment. And if there is any treatment recommended, that becomes part of your probation as well. Do you understand that?
Yes, sir, Your Honor.
The sentence in this case would run consecutive to any other sentence that you may have. Do you understand that?
Yes, sir.
Okay. Is this the agreement that you thought you had reached?
Yes, sir, Your Honor.
Other than what I just talked to you about, did anybody promise you anything or make any threats towards you to try to get you to plead guilty?
No, sir, Your Honor.
Are you pleading guilty voluntarily today?
Yes, sir.
Do you feel like I am making you plead guilty, Mr. Kingery?
No, sir.
All right. Are you acknowledging to me that on February 28th, 2020 in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, sir.
All right, Mr. Kingery, I'm going to accept your plea of guilty today as having been made freely, knowingly, intelligently, and voluntarily. Do you know whether or not you want to have a pre-sentence investigation before I sentence you, which is your statutory right to do, or do you wish to be sentenced today and waive that pre-sentence investigation, which you also have a statutory ability to do?
Since today, be done with it.
All right. Mr. Kingery just wants to go ahead and get his sentence today. Makes sense under the circumstances. Mr. Kingery, having accepted your plea of guilty, I'm going to enter a judgment that finds you guilty of possession of a controlled substance, first degree, first offense, and possession of drug paraphernalia. It will dismiss the remaining charges. It'll sentence you to 3 years on the first of those 2 counts, 12 months on the second. They'll run concurrently, total of 3 years. I'm going to waive your fine and court cost obligation due to indigent circumstances. You have the public defender representing you. So you'll be probated. The probation and parole will set you up with a pre-sentence with an assessment, substance abuse assessment, and that'll be something that you work out with them, and then they'll set it up and you go where they tell you when they tell you. Okay.
Okay.
All right. Officer Bennett, what do you want to tell Mr. Kingery before we leave?
Mr. Kingery, you just need to contact probation and parole once you're released here in Barron County. If you can't figure out a phone number, just report to the office.
Okay.
Are you familiar where it's at?
I am, yes, sir.
Okay. So when you get released, just make contact with us immediately, okay?
It's supposed to be released today. If I don't get out of here in time to get there before y'all close today, just come in the morning or?
Be there at 8 a.m. in the morning. Yes,
All
sir.
right. Yes,
All
sir.
right.
Hey, listen, I think you're gonna get out in time to report today, so you might want to be sure you count on that.
All right, that'll work.
All right. All right. Anything else?
You said I will get out of here in time to report today?
Yes, I think you will. I think you will. Yes.
All right, that's it. Thank you, sir.
All right. See you. Jonathan Kirk. Thank you. All right, so we're here on final sentencing for Mr. Kirk. Mr. Kirk had 3 different cases. Is Commonwealth ready, and is Mr. Kirk ready?
Commonwealth's ready, Judge.
Defense
Okay.
is ready, Your Honor.
All right. Has Mr. Kirk had the opportunity to look at the pre-sentence investigation report?
He has, Your Honor. He reviewed it this morning in my presence.
All right. Are there any corrections that should be made?
None that he made aware to me, Your Honor.
All right. Then let us proceed with sentencing. Mr. Spears, what do you wish to argue?
Your Honor, I know what the Commonwealth's going to argue given the new circumstances, but I would argue that the sentence should be he should be sentenced per the agreement. We're not talking about probation in this case. He's still taking an 8-year sentence. So I would ask that he be sentenced in accordance to the agreement we made about a month ago.
All right, Mr. Richardson.
Just to put things into perspective, he's pleading, or he has pled out to 3 different cases, 2 of which were burglaries and another which was receiving stolen property. So all were similar types of offenses. And basically he had 8 years in each burglary case total, and then 5 years in the receiving. So part of the language in those agreements were that our recommendation would change or be null and void if he were to be arrested or failed to show for final sentencing, which was the case. So I don't feel like sticking to my end of the bargain if Mr. Kirk's not going to stick to his. So what I would ask the court to do is to run that one burglary case consecutive to the other for a total of 16 years. That one that's 5 years can still run. I would ask you can run that concurrent, but I would ask to run those 2 burglary cases consecutive.
The 2 burglary cases to which you are referring would be 20 CR 197, right? And 21 CR 60.
Yes, sir.
And the 21 CR 60 occurred. The offense date on that was while Mr. Kirk was on bond in the 20 CR 197, correct?
That's my understanding, yes.
And by statute, unless there is an agreement to the contrary, you are, if you are arrested and convicted for, did I lose the jail?
That's a long time.
There's the jail right there.
That's a long time, huh?
Of course, it's a long time.
And I got 5 new felonies.
I guess what I'm trying to understand is why you're surprised by this, since this is exactly what I told you was going to happen if you screwed up.
I'm not. But that's a long time. I'd rather pull it all back and box it up. I'd rather take my chance to trial. I'd rather go be 50 instead of 16. I'd rather take my chance.
That ship has sailed, Mr. Kirk.
I'd rather take my chance.
Well, you might have rather taken your chance, but that's not going to happen because you've already pled guilty. And I explicitly went through with you what could happen if you violated the terms of your furlough that you begged me to give you, and I gave it to you, and you violated it. All right. And therefore, the Commonwealth is not bound by its previous offer. The 20 CR 197, that is an 8-year sentence, which I'm going to impose upon you today. The 21 CR 59, that is a 5-year sentence, which I'm going to oppose on you today. The Commonwealth did not object to that remaining as a concurrent sentence, and so therefore I'll go along with that. 21 CR 60 is an 8-year sentence, which, absent some agreement to the contrary, would be consecutive anyway, because you were out on bond when you committed an additional felony. So therefore, that is going to be sentenced to run consecutively to the previous 8-year sentence and the 5-year sentence, for a total across these 3 cases of 16 years. I am going to waive any fines and court costs, and restitution is going to still be a component of your judgment, just like it was agreed to be in the beginning when you get out. All right. Do you have any questions?
No.
Okay.
Hurry up and get this last case up here. Go on, box it up. I don't care about none of this shit.
Hey, Mr. Kirk, come back. Come back.
Talk to this nigga, man. Fucking talk. What do you want to talk about?
Mr. Spears.
What?
I'm holding Mr. Kirk in contempt of court, and I'm going to sentence him to 90 days in jail. I'm reinstating his bond so that he's not getting credit on these CR cases right now. He's going to do 90 days in jail. At the conclusion of that 90 days, he can start serving this 16 years. Okay?
I'm already on parole, so it's gonna count regardless. I'm already done took a PV, so what is it? What is it counting? What is a contempt charge gonna do? I'm already PV'd on my other facts, so it ain't gonna take no. You ain't gonna take no time, so I don't care. What is the charge gonna do?
Hey, hold on and find out.
That's what I'm saying. What is he gonna do?
It's not I ain't giving you advice. All right.
I ain't trying to make you mad, but you just gave me 16 years. What do you think I'm gonna do, man?
Well, I would have thought that you would have thought about that before you screwed up.
That's why I cut it off from ringing. That's why I did it.
You cut it off and ran because you would rather do 16 years than 8 years?
Hey, man, you haven't taken me back. I don't even want to hear this nigga's voice. Sit down. I don't want to hear this nigga's voice no more, man. For real.
Yeah, hold on. It's cold in there. Didn't even know that. I'm sorry.
I apologize, y'all, if I done made this man mad, but like, that's 16 years of my life gone.
I understand. You should have been on influence of drugs.
They know I was had.
Shut up.
When I talked to the man, he knew I was had.
Oh, yeah, then get your lawyer. Tell me the influence.
Bonnie?
Yes, Judge.
If I hear any more from Mr. Kirk, he's going to get some more time. I mean, there isn't any reason for all the rest of us to put up with that nonsense. Rachel Myers Jackson.
This was Greg's client, Judge. We had a bit of trouble getting her to appear for court.
Are you not?
Yeah, you're correct, Mr. Richardson. I'm not sure what, I'm not really sure what we need to do to impress upon her the responsibility to come to court, other than to do what we did.
Yeah, this 5 days in here has really learned me a lesson. I won't miss any more court dates. If you're good enough to give me a surety to get out. I have 2 daughters. My charge partner in this case, he took a complete responsibility for all of this. And that's why I talked to my lawyer, but my court date had been changed to my, and it's not making light of me missing court because I did miss 2 court dates, but it's been changed at least 9 times, you know, because of the COVID.
Judge, I've sent an offer on this to Greg
Yes, sir.
already. I've sent an offer to Greg on this already, and they have discovery. If we could push it off for a week, Greg and I could talk, and I'm pretty certain we can work it out by next week.
Well, I'm inclined to agree. I don't know what, I mean, you know, when there's co-defendants, just because one of them pleads guilty doesn't mean that the other one's not also guilty, doesn't mean that they are either. So I don't know anything about the underlying, you know, facts or discussions that you've had with your attorney, and I don't want you to tell me any of those. But I am, you know, I do know that you had a couple of different opportunities to come to court, and you were aware of those and you didn't come. And your attorney was not able to get much cooperation from you either, because I asked him to get you here the last time and that didn't work. So I am going to, what we'll do is pass this case to Monday, which is the 26th. At 10 o'clock. Your attorney was not able to be here today, and that's not, you know, anything that anybody can do anything about. It's just how it is. So, but Ms. Myers Jackson, I'm going to keep you in custody till your attorney can get here, which, I mean, if it was longer than a week, I wouldn't do it. But since it's next Monday, that's how we're going to do it, just to make sure that you and he get the chance to work on this case and see if you can come up with a plan. Okay? So I will see you Monday at 10 o'clock.
Yes, sir.
Margaret Russell Spate. This is an indictment. So it's an arraignment. Denise, who do you think step in and do this?
Your Honor, I think that we'll also probably need to schedule a hearing on her 2 cases that she's on probation for.
Well, I just assumed we would do those as drug court sanctions. Like,
Oh, okay.
yeah, I mean, she's serving a drug court sanction right now.
Okay.
Yeah.
I think I had some.
I mean, I'm not going to tell you, you can't file a motion if you want to, but I was not planning on evicting her from drug court.
I may have misunderstood Candy when I spoke to her about it. So that's fine.
Well, Candy was pretty disenchanted with Miss Russell Spate.
Yeah.
Yeah. But I feel like I talked her down. So.
Okay.
Maybe I didn't. But this, so I need to appoint counsel for her to, for this indictment, for this arraignment. This is 21 CR 72.
I'm going to ask Ms. Myers to step in for the arraignment, but it will be Mr. Berry's case at a later time.
And Your Honor, we will waive formal reading of the indictment, enter a plea of not guilty at this time, reserve all pretrial and pre-arraignment motions as if presently filed.
Okay. Ms. Myers, you may have heard us saying Ms. Russell Spate is in drug court right now. That's really only about 3 weeks or a month old. She's doing a sanction currently, but I didn't have any plans to, you know, remove her from drug court at this stage. I do not know if this case is going to be able to get resolved with that similar disposition, but I did want to let you know that's what she's doing on her other cases. We can put her pretrial on for June we could do the 7th or the 14th. I can't really remember I know you've got some things going on, Ms. Myers, and I can't remember what exactly they are from one week to the next, some other obligations.
I think this is Greg's case, Judge.
Oh, okay. Well, he doesn't have anything going on in June that I'm aware of, so let's do June the 7th. Denise just told me that and I'd already let it slip by me. 1 o'clock, June the 7th. This case, Denise, for the record, is she's on bond in this particular case that we're talking about right now. So this isn't going to hinder her ability to get out when she gets out. Ma'am, you need to contact your attorney's office if you need them to give you a number. We can talk Bonnie into writing that down for us.
Thank you, Judge.
Thank you. Joseph Slayton. Mr. Slayton.
Yes, sir.
They tell me that you have an agreement worked out in your case.
Yep.
Is that correct?
Yes, sir.
Will you raise your right hand, please? Do you swear to tell me the truth, so help you God?
Yep.
All right.
Yes, sir.
Mr. Slayton, this is a motion to enter a plea of guilty. It's got your case number on it, your name on it. And on the second page, it's got what appears to be your signature on it. Is that your signature?
Yes, sir.
Thank you. This is your offer. Again, it's got your name, your charges. On the second page, it's got what appears to be your signature. Is that right?
Yes, sir.
All right. Did you read over all these things before you signed them?
Yes, sir.
Did you have time to discuss them with your attorney?
Yes, sir.
Did you understand what you signed?
Yes, sir.
All right, Mr. Slayton, do you understand that you have the right not to incriminate yourself and you waive that if you plead guilty?
Yes.
You have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You can confront and cross-examine witnesses. You can put witnesses and other evidence on in your own defense, and you can appeal. Do you understand that you waive those rights if you plead guilty?
Yes, sir.
Mr. Slayton, do you feel like anybody is making you plead guilty today?
No, sir.
Is your judgment impaired today?
Yes, sir.
Is
What?
your judgment impaired today?
No, I'm good.
All right.
Yes.
All right.
I can't sit.
Your charges are possession of a controlled substance, first degree, third or subsequent offense, for which the Commonwealth would recommend 1 year, and drug paraphernalia, for which the Commonwealth would recommend 12 months. Those would be concurrent for a total of 1 year. The Commonwealth opposes probation. Do you understand that that is the offer of the Commonwealth?
Yes.
Has anyone promised you anything to get you to plead guilty other than those promises?
No.
All right.
No.
Have you been threatened?
No.
All right. You feel like I am making you plead guilty?
No.
All right. Mr. Slayton, are you acknowledging to me that on December 5th, 2019 in Barron County, you knowingly and unlawfully possessed methamphetamine, having at least 2 prior convictions for possession of a controlled substance?
Yeah.
And that you possess drug paraphernalia?
Yeah.
All right. I will accept your plea of guilty here today. Do you wish to have be sentenced today or do that later?
No, let's do it today. I got 2 more cases I'm fighting. I'm ready to get this over with.
All right. Well, then I will go ahead. I've accepted your plea of guilty. I'll sentence you to 1 year on count 1, 12 months concurrent on count 2, and for a total of 1 year. Okay, fines and costs waived.
Your Honor, just to clarify, that is supposed to be concurrent with the sentence he's presently serving on.
Oh, yeah, I think maybe it does say that, certainly, so we'll make sure that gets in the judgment if I
What, you
neglect
trying to
it.
just rush me out of the way or what?
Huh?
Trying to rush me out of the way?
Yep.
You tired of seeing me, ain't you?
No, I was just trying to get you down before you said something.
How do you get a year, dog?
Michelle Williams, AKA Spencer. Hello, Mitzi. What's this? Where's this Williams
Freezing
coming
up on
from?
me.
She frozen. All right. Y'all want to do the jail? All right, I believe they're back. All right, are you back?
She reset it. Yes, sir.
Yeah, can you hear me?
Yes.
Okay, you're here for an arraignment on an indictment charging you with the offenses of possession of a controlled substance, first degree, third or subsequent offense, and drug paraphernalia. Do I need to appoint a lawyer for you, Mitzi?
Yes, sir.
Yeah. Denise, who will we have?
Xanda.
All right, Ms. Myers, let's go ahead. Do you want to have a formal arraignment?
Your Honor, we'll waive formal reading of the indictment, enter a plea of not guilty at this time, reserve all pretrial pre-arraignment motions as it presently filed. I noticed that this was a possession of controlled substance charge, Your Honor. I was going to ask the court to look at her bond in light
She's
of.
out on bond. She got arrested out of on a warrant out of Hardin County. She's out on bond for this case.
Okay.
Yeah, I saw her on the website. Her court date that we had set for her was up in May, and I saw her on the website and just asked them to add her so that we could get it while she was here.
Thank you, sir.
So you've been on probation. You did like an alternative sentence out of Hardin County, and then you were on probation, and don't tell me anything about it, but something's happened and they've issued a warrant, right?
Right.
Yeah, all right. So you'll be having to go up there and deal with those folks in Elizabethtown here directly. Let's put the pretrial conference on for June, let's call it the 14th. At 1 o'clock. And then Ms. Myers can, you all can try to figure out exactly what's the lay of the land in your Hardin County cases and see what we can come up with on these cases. Okay. All right. Thank you. Billy Mac Tatum.
Judge,
Yes.
this is my motion to void diversion. I have a proposed resolution. I know that he has been assessed by the social service clinician, and she's recommended that he go to Journey Pure for inpatient treatment. So if he were willing to do that, then I would be willing to withdraw my motion at this time on condition that he did that.
Is that something you're on board with?
Yes, sir. Yes, sir.
All right. All right. And by the way, that was a condition of your diversion anyway, that you comply with the recommendation of the assessment. So I think that's a fair way to handle it. In lieu of Reporting diversion. Bennett to enter complete treatment. Do we know when the bed's going to be available?
No, Judge, I think that at first he was hesitant to go. But I can let Officer Bragg know that he's willing to go and they can get something set up as soon as possible.
All right. So we'll just try to get this set up as, we'll get you a bed date as soon as we can. And once they let me know when that is, I can, I can let you go. Okay.
Okay.
All right. Thank you.
Am I getting out today? Am I getting out or?
No, I don't know when your bed date is yet. Hey, Bonnie, can we rein it in a little?
Do what, Judge?
Can we rein it in a little? I'm having a lot of trouble hearing everybody else. Eddie Vibbert?
Yes, Your Honor.
All right, this is the Commonwealth's motion to revoke probation.
Your Honor, we've reached an agreement in this case. He's
Okay.
been assessed by the SSC. They have, I think they have a bed date at Park Place, if I'm not mistaken, agreed to allow him to go and do that in lieu of revocation.
Okay. Do we know whether there's a bed date yet?
I can look back at my emails. I don't know offhand. Give me 1 second.
Well, I guess let's just, whoever's here with Seth.
Judge, I just talked to Charity. She said it's May the 5th.
All right.
Is the bed date, and she asked as well if he could be held until that bed date.
How's he gonna get there?
She didn't specify, Judge. I don't know about the transportation.
All right.
We could transport if he doesn't have anybody to take it.
Right.
Well, I mean, I guess if you all could just kind of keep me in the loop on that, because I like to put transportation. I mean, I'll do an order, but I like to put the transportation arrangements in there so that everybody doesn't, just stand around and stare at each other.
Yeah, I'll let Charity know to update your office.
So I guess getting that on an ankle bracelet's out of the question, Your Honor.
Yeah, that's not going to happen today.
All right.
Okay.
Hey, I got another question for you. Yeah, I got another question for you, sir. Hey, my Russell was up here a minute ago. How are y'all charging her for when I pled guilty on that, sir? We was co-conspirators in the same case. I pled guilty on the trafficking. How y'all charging her too, sir?
Well, because by definition, if people are co-conspirators, that means they're both conspiring.
But I pled guilty to it, Your Honor.
Well, it doesn't. I mean, you can have 100 people plead guilty to a conspiracy.
Well, that don't make no sense, but okay.
Well, I mean, it doesn't have to make sense to you. That's how
I
it is.
understand that.
Yeah. I mean,
hey, none of it makes sense to me on it, but hey, it's all good. Thank you.
Your Honor,
yes.
could we recall Mr. Tatham? I have some information about the treatment.
Right. Bonnie, yeah, there he comes.
Judge, Officer Bragg let me know that what was recommended for him was a short-term inpatient program at Journey Pure. And since it's a short-term program, DOC doesn't arrange that. Mr. Tatham is supposed to call, arrange that, and do the intake paperwork.
Okay.
Take care of that. There.
All right. So, I mean, does that mean he's got to be out to do that?
That I do not know. He also said he was going to ask the social service clinician if that's something that they could arrange.
Well, I mean, yeah, that's fine. I just need to know what to do with him when he walks away from this camera. I need to know whether he's going to be getting out or not.
Okay. I guess I wouldn't be opposed to him getting out on condition that he called today and figure that out.
Yeah. Who's your probation officer, Mr. Mr. Taylor?
Bragg.
Yeah.
Bragg.
Yeah. So here's what you need to do. I'm gonna go ahead then and release you so that you can get this arranged, but you need to call your probation officer and report to him when and as frequently as he tells you until you get your bed date.
Yes, sir.
All right?
Yes, sir.
All right.
Judge, I'll let Officer Bragg know as well.
All right. Thank you. I don't think right. It's the same upshot. All right. Thank you. That'll be in our order. But yeah. Correct. All right. Bonnie, who else you got?
I got Scott Mars.
Well, we're doing him next Tuesday in Metcalfe County.
Okay, Judge.
All right. We'll see you in a little while.
See you in a little while, Judge.
All right. So all right. Let's get this back up and running. All right. Vanessa Bray.
Your Honor, that's my motion based on a new district court case.
Yes, sir.
All right.
What I would like to do is schedule a hearing, maybe the first hearing date in June. She has a pretrial in district court on, I think, May the 13th. So I want to see what happens with that. And additionally, I think she had been told by Officer Bennett to contact Life Skills, I believe, for an assessment. So just she can follow up with.
I told him that I was going to Life Skills. I got into Life Skills on my own, but
Okay.
I'm signing over to where y'all can see what I'm doing, like treatment notes and stuff.
All right, Vanessa, hold on a minute. Officer Bennett, jump on here, will you?
Yes, sir.
What do you need to tell Miss Bray? She's not in custody. We're going to set the current motion for June the 8th at 1:30. What do you need to tell her between now and then that she should be doing?
She explained to me on her last report day that she had a life skills appointment on April 12th. So I would just encourage her to make all dates recommended by them and to keep her next report date until we figure out how to proceed with the motion.
Okay. All right. Denise, I need to assign her an attorney, and I think her attorney that she had when all this started is left.
It is going to be Xanda.
It'll be me,
All
Your
right.
Honor.
Okay, good deal. All right, so June the 8th at 1:30, okay?
Okay, thank you.
All righty. Anthony Redwine?
Yes.
All right, Mr. Redwine, you are on here today. Because I'm trying to track this down. It looks like you did a pretrial diversion back roughly 2 years ago.
Yes, sir.
And it is supposed to, basically it's supposed to end right around now, unless there's some reason for it to to not end, but I don't see anything in here. He completed his U-turn, and I don't see any other reports or complaints. So does anybody know anything I don't about this case? All right. Your charges are going to be dismissed then.
All right. Thank you, sir.
Okay. Tell me your address and I'll make sure you get a copy of this.
103 Warren Street, Burkesville, Kentucky.
You say Warren?
Yeah, WARREN. And Jeremy Garmin told me to ask about my my felony or whatever, my rights and stuff. Will I get those back?
Yeah, you're not going to be convicted of a felony. When this order gets entered, it's dismissing your whole case. So you don't have none of these. You're not convicted of any of these charges.
Okay.
Okay.
Thank you, sir.
So if that's all that if you were worried, if he was worried about, well, hunting rights and that kind of thing, shouldn't be affected.
All right. Thank you, sir.
All right. Any other questions?
That's it.
All right. Thank you.
Thank you.
Judge,
Yes.
this is Ken Garrett. One of my clients, Cosmos Bohr, just messaged me and said that he's got to pick up his child from school because one of them is sick.
All right.
Could you call his case so that he can be on his way to do that?
I can. He's right here. Mr. Bohr. Mr. Bohr, you are here for what we call an arraignment on a charge of assault in the 4th degree and strangulation in the 1st degree. Is Mr. Garrett your attorney? Oh, Mr. Bohr, you're on mute. Your device is on mute. If you can undo that for me.
Yes, Your Honor.
All right. Mr. Garrett is your attorney, correct?
Yes.
All right. Mr. Garrett,
Judge, I'll waive formal reading of the indictment, acknowledge his identity as being the same person named in the indictment, acknowledge having gotten a copy of the indictment, and enter a plea of not guilty on his behalf.
okay. So, Mr. Bohr, I am going to put you down here as a not guilty plea. We will set you what we call a pretrial conference for June the 7th. That'll be at 1 o'clock. We will be meeting in person when that rolls around. So, we won't be doing Zoom. We'll be, you'll be coming in person. I need for you to be sure you talk to your attorney and stay in contact with him before then. Okay.
Thank you, Your Honor.
All right. And then you have been out on bond this whole time. You just remain on the same bond with the same conditions as before. And if you have any questions, you can check with your attorney about those. Okay.
Okay, thank you.
All right. Thank you. You're free to go.
Thank you, Judge.
Yes, sir.
Judge, that was June the 7th, correct? Pretrial.
Yeah, June the 7th.
Could we take up Mr. White, Judge?
Yeah, when did he come in?
He got on right after we spoke. He's the 799-3319.
Oh, okay. All right. Mr. White?
Tommy, can you hear me?
Yes, sir.
This is an arraignment, Your Honor. We would, if you please, the court acknowledge receipt of the indictment, acknowledge Mr. White being the one named in that indictment, waive formal reading, enter a plea of not guilty, ask to reserve the right to file any all motions pertaining to Mr. White's case.
I need to know Mr. White's current address.
Currently I'm homeless, Your Honor. I don't have an address.
Well, I'm not trying to be a smart aleck, but where'd you stay last night?
Hotel room.
Is that where you're going tonight?
I just woke up. I really don't know what's gonna happen by the end of the night.
What's a good mailing address, Tommy?
See, I really don't know where I could have some mail sent to. My mom, she lives in Muhlenberg County, but I don't know her address.
Would it be all right, Your Honor, if we accepted the service of mail for him here at the office?
Yeah, I just, when things come up and you don't have any way to send people things, then they don't show up and then they end up getting warrants, and the whole
Yes.
point of all this is to try to keep that from happening. I'm not trying to be nosy. I'm doing it for his own good.
I understand, Your Honor.
No, I understand, Your Honor.
I would accept his mail here, Judge. He's always been easy for me to get a hold of.
All right. So, Mr. Bell, let's do a pretrial conference in June. I can't remember if I set one on for you earlier. If I did, we'll pick the same day, but I don't remember what day we picked.
Yes, sir. It was
14th, wasn't it? June 14th?
Yes, Your Honor.
Yeah, that's what I thought. All right. So let's do that. June 14th at 1 o'clock. Tommy, stay in contact with Mr. Bell, all right?
Yes, sir.
All right. Any questions?
No, sir.
All right. Thank you.
Thank you, Judge. Y'all have a
Thank
good day.
All right, let's see. Who else do I got? Mr. Houchins.
Yes, sir.
There?
Yes, sir.
All right, let's see. We're on here for, is it going to be some kind of payment review?
Yes.
Can anybody tell me where we are?
Judge, we've got printouts from child support. And it looks like, when was the last time we were in court? What was the
last date was the October 12th.
Okay, since that date, he's paid $100 on February the 1st. Also $300 on February the 1st. And then $200 on April the 13th are the payments that have been made since that date.
And I've made one on March 1st. 200 on that. I was trying to look for my receipt here.
Well, it looked like from October to now, he would have been owing us about $800. So I don't know if those numbers add up to about $800, either 700 or 800, depending on whether you counted this month as being due yet.
Yes, I've got it all up to current. And I do.
Yeah, I'm showing payments, or I'm seeing payments of $600. So if he's got another receipt for a $200 payment, I'm not.
Yes, I've got it right here.
All right. Well, why don't we review it down the road there about 4 or 5 more? I think we were looking at every 6 months, so I can do that if you all want to. Of course, I always hear that, and I understand it, when you're self-employed, the winter is the worst and all of that. It seems like to me when the weather gets nice, you ought to be trying as hard as you can to maybe work out paying more than, because you're going to hit a dry spot in the winter. So, I'm not going to increase your payment, but I'm just telling you that, that's how you pay it when you got it. You know what I mean?
Yeah.
All right. So let's go to October the 25th, which is 6 months. Now, if payments aren't being made, the Commonwealth will get notified and we might end up having to file something and see you before then. But as long as you're in here plugging away on it, getting your money paid at $100 a month, maybe everything will be all right. Okay?
All righty. What time?
10.
10. All righty.
All right. See ya.
All right. See you. Bye-bye. Okay.
All right. All right, let's see. I'm gonna have to just, most of the other ones I've got, I don't have names on and I don't have my docket here, so I don't know who all I'm looking for.
Judge Holly Short's been on.
Oh yeah, Holly Short. I do have her name. Good point. All right, Holly Short.
Judge, this motion's been pending for some time. It's a motion to revoke misdemeanor probation based on a new felony charge, which is a possession of meth and some other misdemeanors. It's typically something I would resolve with Rocket Docket. So I guess my offer would be, if she was interested in resolving this new felony case, would be for her to go back to drug court. I've spoken with Candy about that. So if she was interested in that type of resolution, I would just maybe ask that we put this hearing out till the end of May in order for her to get assessed and potentially resolve this new felony case.
Short, did you hear that?
Yes, sir.
Is that something that you want to think about doing?
Yes, sir, please.
I'm sorry, were you asking me a question?
No, I said yes, sir.
Okay, good enough. So Risa, what are you thinking, that we can give her Candy's number and have her contact Candy and then just come back in 3 or 4 weeks?
Yes, maybe. I mean, we don't need to put it on a hearing day, just put it on a Monday.
Right, sure. Why don't we put her on for Monday, the May the 17th?
Judge, could we do it on another day? Can we
Okay.
either do the 10th or the 24th, please?
Well, I think all the DPA will be gone the 10th, so
Okay.
we better go the 24th. All right, and then let's give her Candy's number and have her call Candy and, start talking to her between now and then, okay?
Okay, Ms. Short, do you have something to write her number on?
I do, yes.
Okay, it's 270-576-1111. And I will send her a message now to tell her you'll be calling her.
Okay, I thank you so much.
All right, Ms. Short, so call her, in the next day or two, okay?
I sure will.
All right, thank you.
Thank you.
And I think Rebecca Brown was on here earlier, which is it's a motion I have, but it's a drug court case.
Right.
Is she still on? I wasn't sure if she was actually still on. I had filed a motion and I had actually put it on the docket for today, but I didn't provide enough notice. So I'd tried to re-notice it for next Monday. I wasn't sure if she was still on. I let her know that I didn't see it on the final docket.
Yeah, it's not on the docket because when you re-noticed it, it got moved to next Monday. But she was this phone icon here that was 270-599-9734. That was her. Yeah, we can hear you.
Okay.
Yeah. Your Honor, I think I forgot that Ms. Myers was representing Ms. Brown, and this is when I spoke with Candy, and she's willing to resolve the drug court violations by her going to Kentucky Recovery if she'd be willing to do a treatment program there, if you want to discuss that with her.
I'll probably need a little additional time to discuss with her.
I would
Part of her
understand
part of
Yeah.
our issue has been transportation. So, you know, we would have to try to work that out too. I'm not sure how she would actually get to Kentucky Recovery.
Well, can we leave yours on for next Monday and maybe you can talk with her between now and then and we just won't take any action today since she's not on the docket?
That'd be fine, Your Honor. I think she actually has an outstanding warrant. Would it be possible to withdraw that warrant until, or remand that warrant until next Monday?
Yeah, we can.
She's been in pretty frequent contact with me. I just didn't want her to get stopped or picked up between now
Yeah,
and
no.
then.
We can, because, you know, we've got all the players here in the same place talking about the same thing and I'll give her a chance to, you know, do better this time. Yeah. And it'll be on Monday at 10, okay?
Monday at 10.
Yes,
Okay. Thank you,
All right.
Judge.
thank you. I believe that, yeah, there's Charlie Runyon. He's fixed it to where now his name's on there. Before it was some combination of letters. and
Yeah, I'm here.
esoteric symbols, things of that nature. I guess this is payment review, right?
It is.
Yes, sir.
Well, Mr. Runyon, what you got for me?
I think I was all caught up except for last month and this month. I paid the $550 like you asked, but I dislocated my knee last month and I'd been off up until the 29th of March. And let me get where you can see it. I got a doctor's note. Sorry about all the kids, but you can see the doctor's note. It's a little, my phone's not the best, but it's from Dr. Helsley. I returned to work on 3/29/21, and that's all his information there. I'll make.
Did you go to the vet or to the other Dr. Helsley?
I went to I went to Dr. Helsley at Western Kentucky Orthopedics.
Oh, okay, good deal.
So, I mean, really and truthfully, all I'm behind's $100, and I'll actually pay it whenever I get off the phone. I would have been on earlier, but the lady in the clerk's office gave me Gabe Pendleton's link instead of yours. So,
how'd that go?
well, he got on there and he's like, "I don't have you." I was like, "Yeah, I was pretty sure I was supposed to be in John's courtroom, but I'm here with you now." So I had to call back up there and get everything.
All right, so
I'll make $100 payment as soon as I get off the phone. I'll be current. As of today, I'll be current. If you want to put it off till, like, we've been doing it every 6 months. I heard you say something to another guy earlier about stimulus payments and all that. About putting it towards restitution. I wasn't quite aware of any of that.
yeah. Well, I think with your situation, because you're already off of probation,
Yeah.
and it's just a matter of you paying what you heard me talk about was that guy was he was on probation and that was a condition of his probation that he didn't make any payments. He didn't spend his stimulus money if he was behind.
Okay. I was gonna say.
I don't have a probation officer keeping up with you, so
Yeah.
you know what I mean?
Yeah.
So listen, we can put this 6 months is October 25th. So, we can put it down there. But, you ought to be able to
Yeah.
get maybe a little bit more than the minimum paid while this weather's nice,
Weather ain't got nothing to do with my work. I'll just be honest. I'm gonna just ride the minimum out. I mean, I don't want to pay it to begin with. I'm just trying to give it time to get it back in court to turn it over to a civil matter and then just file bankruptcy on it again.
Well, I can't get mad at you for not paying more than the amount I ordered you to pay. So,
Yeah, that's it. I mean, like I said, I'm gonna ride it out, pay the minimum until I get you got 7 years. That's all you got. Cause actually you got 5 years now because I filed bankruptcy 2 years ago. So, whenever I get that done, I'm gonna try to get it turned over to a civil matter so I can just do away with it.
well, we'll see what happens there. But in the meantime.
Well, I don't know where it's at. It was in Judge Patton's courtroom. He told me that in the courtroom. I just don't know where it was at, like what day or whatever. Temple Dickinson was my lawyer at the time. So, yeah, I kind of got, I didn't get screwed, but Temple passed and, Judge Patton's not in there no more. So I don't know where to turn to get that date to where he put that. I don't know if he put it in or he just said it, but I know he said it at least. So.
I got you. All right. Well, look, your next date will be October 25th at 10 o'clock. Okay.
Okay.
All right.
And that should be, how much is that? 6 months? That'd be $300, right?
$300. Yep.
All right. That's fine.
All right.
I'll go ahead and take care of the 100 today. That's behind though.
All right. Good deal.
All right. Thanks.
You bet. Who, let's see. Sir, what's your name? You look like you're in your truck or your car and your phone is a Moto E6.
Tracy Haynes.
All right, good enough. I'll take your word for it. When some of these on the phones, they don't show up with anybody's name, so you don't know who they are. All right, Mr. Haynes, is your date of birth September 5th, 1969?
Yes, sir.
All right. Can you tell me your address?
568 Ray Purdue Road, Scottsville, Kentucky.
Very good. Do you need to discuss with me about having an attorney appointed, or do you
Yes,
have?
I don't even know who my attorney is.
Well,
but the last time we went to court, we all had masks on and we was on TV screen. I had no idea what was going on.
Yeah, that was when you were in district court, wasn't it?
Yeah.
Yeah. So it looks like, yeah, they appointed an attorney for you in district court. I don't know who, they didn't write the name down. So what I'll do is I'll appoint an attorney for you up here. Denise, who's going to get that, you think?
Zanda's going to cover the arraignment for me, and then it will be Greg.
All right. So Mr. Haynes, what we're going to do is we're going to do an arraignment, which just means that you tell me whether you're pleading guilty or not guilty. And I'm going to go out on a limb here and think that your lawyer's going to want you to plead not guilty. And then we'll set it for a pretrial conference where they can all exchange information and find out what's going on and so forth. And then we'll give you a future date, for you to talk to your lawyer and come back and see us. Okay.
Okay.
All right. So Ms. Myers, how do you want to proceed?
Your Honor, we will waive formal reading of the indictment, enter a plea of not guilty at this time, reserve all pretrial pre-arraignment motions as it presently filed, and ask for an order of discovery.
All right. So Mr. Haynes will plead not guilty on your behalf here. We will appoint counsel. We'll set this for a pretrial on, let's call it June the 14th.
June 14th.
Yes, sir. At 1 o'clock. We'll get you a phone number so you can call your attorney and make an appointment to speak with him before that day, okay?
Yes, sir.
All right. Denise, you want to fire that off for him?
Are you ready?
Yes, sir.
833.
Yes, ma'am. I'm sorry.
That's okay. It's 833 385 6055.
6055.
Yes, sir.
What's his name?
Greg Berry.
Big Barry. Okay. I'll call him just here in just a little bit.
You might want to give us a few days to get all of your paperwork in, if you don't mind.
Okay. All right.
Thank you.
All right. All right, Mr. Haynes, anything else?
No, that's all.
Okay, thank you.
Thank you, buddy. Your honor.
That's all right. It's been a long morning.
Oh, it is.
You're free to go.
All right. Thank you. Thank you.
Stacy Burnett, that is a pretrial suspension review. I don't see anything in here saying that she can't be dismissed, so unless y'all tell me something. Ashley Costello. Her probation officer emailed me and said she was in treatment at Journey Pure. The circumstances were such that she would not be able to get on the hearing, I guess because she just went. And her probation officer said, I will let you know when she completes treatment so that this motion can be rescheduled. I'll probably, in lieu of doing that, I'll probably just reschedule it and then we can move it. I mean, I don't want to just leave it hanging open. So I'll reschedule it for a couple months down the road and then we'll just keep checking on her. Okay.
I'll notify the officer, Judge.
So let's put it on, I don't care what we got. July 26th, that's 90 days.
And just so everyone's aware, this case will be taken over by Ms. Myers as well.
Okay.
What date was that, Your Honor? July?
26.
Okay.
All right. Anthony Dalton. That one is, he posted bond in December. I do not have any idea where he went or what he's doing. His court date obviously didn't survive COVID. I did forget until I saw his indictment. His AKA is Cameron Lucifer, which is, at least stimulates conversation.
He's got that going for him, right?
Yeah, that's right. So I don't know where to go with that other than I'm going to probably put it out about a month and reissue a summons for him and see how that works before I declare him whereabouts unknown. So we're going to put him on we'll do May 17th. $10 a.m. issue summons. Justice Deckard. That is a pretrial diversion review. This Justice Deckard has been on inactive supervision since May of last year, so I'd say that's okay to. Virginia Rodriguez, she is in jail, and it just now occurred to me we didn't see her, so I don't know why. Maybe they can get her on the afternoon docket. We'll see. She's in jail for a bond violation or for a probation violation. James Ryherd, he's out of custody. I think this is actually his pretrial. No, I have no idea why he's on. Because you all had filed a motion to void diversion at one point and then withdrew it. This may be just to see if he's paid his court costs. Is that possible? Anyway, it's not going to require it.
Yeah, I think it's just on for some type of payment review.
Yeah, well, whoever's still with me, Seth,
Yes, sir. Judge, I was looking through, it looks like they had a violation on him back in February 25th. I'm not sure if that's been resolved. Other than that, I don't see any issues.
no, I mean, the report said to the current recommended sanction, refer to SSC. So they didn't file a motion, and I guess he got referred to the SSC. But you pass along to, I think it's Chase.
Yes, Chase.
Pass along that he owes this $190. I mean, I don't plan on doing a warrant on him for not paying $190 unless it gets to the end of his diversion.
I'll do it, Judge. I'll notify Chase.
All right. And then we got, last but certainly not least, Brent Simpson. Motion to revoke probation. But that's all I know about that. I don't know whether.
Yeah, Judge, I filed it. Chastity indicates that she can't get in touch with him, hasn't been able to get in touch with him. It's contacted his mom, his ex-wife. They don't know how to get in touch with him. So at this point, we filed the motion and he's not reporting.
Wonder if he's failed to appear at any of these court dates that he got for all these traffic cases.
Judge, I can look that up real quick if you want me to.
He got I mean, they haven't been very recent, I guess. They were, one of them was January, one of them was July of last year in Bowling Green. Yeah. Sounds like maybe I might have to do a warrant on Mr. Brent.
He's got an arraignment for 429 in his Barron County one. At Warren County.
Of course, that's all virtual anyway, so it really doesn't help.
He's got a failure to appear on 322 on that.
All right.
There's an FDA issued 322/2021.
Well, I'm going to have to do a warrant there because Officer Coates' report is basically probable cause that he has absconded from his supervision by not. I mean, I guess I can swear you in if you want me to ask you. Charity, Chastity. I get all my cardinal virtues mixed up.
I answered either one, Charity or Chastity. I answer.
Luckily, I don't call you Prudence. All right. All right. I believe that's all I got on here. So I'll see you folks. We'll try to get going around 1 if y'all don't mind, so we can get as much done as we can get done before the jail gets on. I mean, we don't have to get, it doesn't have to be right at 1, but